This is not a normal day in court. In a few moments, a judge, visibly furious, will halt proceedings for a reason you will not see coming. It's not about the crime, it's about the defendant's clothes. We are about to witness the case of Chardon Lockhart, a woman charged with attempted arson, who walks into the courtroom in a filthy uniform, triggering a chain of events that exposes shocking jail conditions. But that's just the beginning. This hearing is a roller coaster of legal blunders, emotional bombshells, and a stunning pregnancy reveal that changes everything. Judge Boyd will move mountains to give this defendant a second chance, crafting one of the most comprehensive support plans imaginable, but will she take it? The answer lies in a second, future hearing, where a devastating update and a final unbelievable choice will leave the entire court stunned.
Yes. Yes. If you'll have her come up, please. Hello, Ms. Lockhart. All right, Ms. Lockhart, we're going to bring you back on July 27th. My understanding from probation is you have an appointment with them on July 20th, okay?
Okay.
All right, so we'll bring you back on the 27th to see where we are. Yes.
One other thing, Judge, we talked about mental health.
Mhm.
She apparently told somebody in the system that she's not interested. She is interested in mental health court. She and I discussed that today. She understands a little bit more about health court and part of your probation. And I think that's a fantastic program.
Okay.
I would highly recommend that she either be re-screened or whatever she's.
Well,
This is the moment the entire case pivots. Forget the legal arguments for a second. Judge Boyd stops everything to address the one thing nobody else is talking about, the defendant's filthy uniform. Why is her outfit dirty? She asks. This is an incredibly rare and powerful move. The judge's concern for basic human dignity completely overshadows the criminal charge at hand. She isn't just a dispenser of justice. She's a person looking at another human being who appears to be in an unacceptable state of neglect while in the custody of the county. Her questioning isn't just directed at the defendant, but at the entire jail system. The subtext is clear. How can we rehabilitate someone if we can't even provide them with clean clothes? This is a judge looking at a systemic failure, and she's not about to let it go.
here's the thing. You have to discuss that with your attorney and counsel. If you want to speak with mental health court and talk to them, you can. And they will have your client with you on that at that time, if you want to be there with her for the interview. All right.
Okay. Can you restate with you? Okay, so probation.
Probation is going to come visit you on July 20th because that's when you're scheduled for your next evaluation.
Okay.
And then we're going to come back on July 27th because I will have that report so I'll know what's a good placement for you.
Yes.
All right. So do you want to go to mental health court?
Not
I mean, you can discuss it with your attorney, okay? Now, here's my other question. Why is her outfit dirty? I mean, this is not, I have dirt that just won't come out of an outfit. It's dirty. Does anybody know why her clothing is not clean? Are they not doing laundry at the jail? I mean, am I the only person seeing this, that her outfit is dirty? I mean, were you crawling on the floor or something in your outfit, or did they give that to you like that? All right, so we're gonna have to, I'll call the jail and see what's up with laundry. I mean, I know they,
Yeah, I think you could sheets dirty too.
your sheets are dirty too?
Where are they keeping?
Okay.
But I mean, is it just regular? So
It's I can't remember.
it's GP.
Cool.
So no, it's GP. So
All right, so I'll call over there and see what's going on with the laundry.
Most judges would stop at expressing their displeasure, but Judge Boyd is putting her authority where her mouth is. She explicitly states she will personally call the sheriff to investigate the jail's laundry situation. She even adds she'll talk to him about deputies being overworked. This is a significant flex of judicial power, extending her influence beyond the bench and directly into the administration of the county jail. She is using her position not just to sentence an individual, but to hold the entire system accountable. She's signaling to everyone in the room and to the defendant that her concern is genuine and that she is willing to advocate for those in her courtroom, even on matters of basic hygiene. This act builds a foundation of trust, showing the defendant that this judge genuinely cares about her well-being.
I think they have the trustees to do laundry. Okay, I'm sorry.
It was making me itch.
Okay, well, here's the thing. As I tell people, when you're at the jail, you're not going to get the detergent and then they're going to put some Downy in the rinse cycle
They don't clean.
or sheets. Your detergent just says detergent. The soap just says soap. So, but I'm going to check on that at the jail. And so you're saying sheets are not being washed and the uniforms not being washed?
Yeah.
Okay, all right. I will talk to the sheriff about that.
Thank you.
And I'll talk to the sheriff about deputies being worked overtime, but that's all I can do is put that out there. All right, is there anything else?
Your Honor, if I may.
Yes.
If we're going to re-refer over to mental health court, I'll just give you an order to sign.
Yes. Okay, but that won't interfere with her scheduled 20th date.
We're gonna keep that date as well.
Okay, all right, so your attorney is going to talk to you about mental health court. So we can't do this thing where you tell them you're not interested and then we do this back and forth. We don't do that, okay? So your attorney will speak to you about that, but I will see you back here on the 27th. Yes, and I'll talk to the sheriff about the outfits and the clothing.
Thank you.
You're welcome.
Sure.
You keep saying, yes, sir.
No, I said yes, Your Honor.
No, you said, yes, sir.
I said yes, Your Honor.
I would
Okay.
say, I heard yes, Your Honor, as well, Judge.
Okay. All right, are you proceeding on the,
One moment.
are you proceeding?
Here we see a critical but common courtroom tangle, paperwork errors. The charge was reduced from a state jail felony to a Class A misdemeanor, a huge difference in potential punishment. However, the plea documents are still the old felony forms, causing confusion. Notice how the defense attorney politely but firmly corrects the judge, pointing out the correct punishment range on the first page. And what does the judge do? She immediately concedes, "You are correct," and praises the correction. This is not a sign of weakness. It's the hallmark of a secure and competent judge who values accuracy over ego. It ensures the defendant's rights are protected and that any plea she makes is based on a perfect understanding of the stakes. For the viewer, it's a lesson in why every single detail in the legal process matters immensely.
Now, the indictment is presented.
Judge, we're going to go with the lesser included offense of attempted arson, recklessly causing damage.
Okay. Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right. Oh, you're right. She did say yes, Your Honor. I don't know why it sounded like sir. My allergies are really, I apologize. My allergies are really acting up today.
And Judge, I whispered to her that she needs to speak up and not say it, so she had no.
Okay, that's okay.
Thank you, Your Honor.
Because sometimes people always say that and I'm like, what? All right. Did you understand the state is proceeding on the lesser included offense of attempted arson, recklessly causing damage as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Actually, Judge,
I believe, Judge, since it's attempted, the arson, recklessly causing damage is a state jail, and since it's attempted, it's a Class A misdemeanor.
Okay, why do you guys have this filled out as a state jail?
It should have been
the
changed.
first paragraph specifically should list it as a Class A.
All right, so you all need to redo this piece of paperwork.
Sure.
And I would suggest that you use the felony paperwork.
Judge.
That way you can write it in, because otherwise
It's difficult.
I don't have knowledge that she knows that it's a Class A, because that's not how it's listed.
That first paragraph I wrote A right next to it. That's my handwriting. First page, Judge, it says range of punishment, and it listed up to a $4,000 fine up to a year in jail.
Oh, okay, you are correct. Look at
Every
this.
once in a while, Judge.
Corrections are happening. I appreciate it.
I hate to correct you, Your Honor.
That's, no. Here's the thing. I always tell people,
Sounds good.
make sure that if I'm saying something that's incorrect, to let me know, okay?
That's what we did there.
All right, so this is what I'm gonna need you all to do, though.
Yes,
I
Judge.
need her to initial it, so I know that she knows, because all of this is state jail felony paperwork. That's why I say state jail.
Sure.
Sorry about that, Judge. I saw that. I thought about using the other paperwork, but I didn't know if that was probably the better way. From now on, I'll probably try and do that.
Okay. Because all this paperwork is state jail felony paperwork.
I tried crossing out, it was the felony, the discussion about the felony, with the felony in possession of a firearm. And I thought I caught everything else. I think I changed everything to reflect.
Yeah, we
Okay.
erased all of the stuff about the firearm possession because that doesn't apply because it's not a felony.
Okay, let me carefully read through the paperwork. Just give me a moment to make sure that everything is the way it should be. All right. All right, so we're back on the record. All right, they're charging you as arson as a class A misdemeanor. The range of punishment for that offense is up to $4,000 fine and up to a year in the Bear County Jail. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
The judge is now shifting from a procedural guide to a sharp interrogator. She's found a major contradiction. The defendant, Miss Lockhart, claims she has a home to go to with her father, yet the police report for the arson charge, which she just agreed to, implies she was homeless and set a fire simply to dry a wet blanket. The judge is not letting this go. She lays a trap by calmly stating the facts from the report and asking the simple question, why were you homeless? This is a critical moment of truth. The judge needs to know if the defendant has a stable foundation to build her probation on. If she's lying about something as fundamental as her living situation, then any chance of a successful release is already in jeopardy.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court only has the authority to sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine?
Yes, Your Honor.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
If I could answer a little bit more, Your Honor. Yes, I do believe she does. She's mentally competent. She was done a psych evaluation for competency a few months ago. She has been found competent after discussing the case with her today and last week as a jail visit. I agree she is competent.
All right. So she's already been to the magistrate's court and they've deemed her competent?
That's correct, Your Honor.
All right. Do you believe she was sane at the time of the offense?
Yes, Your Honor.
Ms. Lockhart, has anyone threatened you, coerced?
I have no idea. With those 4 words, Miss Lockhart's credibility plummets. When confronted with a direct question about why she was living in a field if she wasn't homeless, this is her answer. It's a disastrous response. It's either a blatant lie or a sign of such profound cognitive or mental health issues that she truly cannot account for her own actions. Either way, it's a massive red flag for the judge. You can see the judge's strategy change in real time. She realizes she cannot get a straight answer on this crucial point, so she pivots to another observable fact to get to the truth. The color of the defendant's jumpsuit. The judge knows she needs to understand what's really going on with Miss Lockhart before making any decisions about her freedom.
Do you replace you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
All right. The court will find that defendant has no.
This is the bombshell that changes everything. The defendant is wearing a yellow jail-issued jumpsuit, and when the judge asks why, we get the one-word answer, pregnant. Suddenly, the stakes of this hearing are magnified tenfold. This is no longer just about sentencing a woman for attempted arson. It's about the immediate welfare of an unborn child. The defendant's instability, mental health, and potential homelessness now pose a direct risk to a baby. You can almost feel the judge's calculus shifting. The need for a structured, supportive, and stable environment is no longer just a good idea for probation. It has become an urgent, non-negotiable requirement. The focus must now be on protecting the most vulnerable person involved, who isn't even in the room.
And voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
Okay, according to the plea, the state is proceeding on the lesser included offense of attempted arson recklessly causing damage. They're recommending deferred adjudication. They're taking in consideration County Court Cause number 634806, and there's to be a MIC evaluation. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There you are.
Next, I'm showing you outside the plea bargain agreement. State is recommending that your deferred adjudication be for a term of 2 years and there be a TAP evaluation. All right, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
That's to follow the plea bargain.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 Morris.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought me.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not.
In response to the pregnancy, the judge doesn't just hand down a sentence. She builds a fortress of support around Miss Lockhart. Listen to this list: a referral to felony drug court, a full mental health evaluation, parenting classes, job placement services, regular drug testing via a UA hotline, and even monitored visits to ensure compliance. This is an incredibly proactive and compassionate approach. Judge Boyd is essentially creating a custom-made rehabilitation program from the bench, addressing every single one of the defendant's apparent issues: substance abuse, mental health, and lack of life skills. She is giving Miss Lockhart every possible tool to succeed, not just for herself, but for her baby. This is a judge going far beyond the letter of the law to try and fix a life.
Not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out, why were you homeless and why would your father let you live with him now?
Judge, if I could just have a second.
Here's the thing, Ms. Lockhart, you need to be honest with me because I'm trying to figure out your conditions. And let me just tell you, one or two things are going to end up happening. If I don't believe you're going to be honest with me, this is going to be set for a PSI. You're going to be sent back to Bear County Jail. They're going to do a PSI report and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions and you need to answer my questions honestly. Now, in this police report, basically it's implying that you were homeless because it said there were clothing and other items and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
So why were you living in this field or wherever it was with your items?
I have no idea.
Just when you think the judge has done everything she can, she offers one last incredible lifeline. Even after Miss Lockhart has formally entered her plea, the judge instructs her attorney to seek a referral to mental health court. She then explicitly states that if Miss Lockhart is accepted and completes that program, the court will grant a motion to withdraw her plea and the entire case will be dismissed as though it never happened. This is a golden ticket. It's a procedural backdoor to a completely clean slate, an opportunity that most defendants could only dream of. The judge has effectively given her a get-out-of-jail-free card, with the only condition being that she gets the help she so clearly needs. The question now is, will she cash it in?
I don't know how to answer that.
All right, so why is she wearing yellow today?
I'm pregnant.
Okay, I just wanted to hear it. And how far along?
We now jump forward in time. Months have passed since Judge Boyd laid out a comprehensive roadmap for Miss Lockhart's salvation. She was given a chance at a full dismissal, a custom-built probation plan, and all the resources the county could offer to ensure the safety of her and her unborn child. But now she is back in the same courtroom, in front of the same judge for violating that very probation. The question on everyone's mind is what happened. Did she take the help she was offered, or did she throw it all away? We are about to find out. And the update she provides will be more shocking and tragic than anyone could have anticipated. The most dramatic moments of this story are still to come.
Like 21, 22 weeks now.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside of it, but she understands she's going to take the parenting class going forward, because that's going to be her.
All right. And is she on medications at the jail?
Yes, Judge. She was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational, but at this time, she is going to be successful going forward. There is a part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
All right. Do you have any other children?
Yes, I do.
How many?
2.
And where are they?
Out of town with my family.
And what are their ages?
11.
They're both 11, twins?
Mhm.
That's either yes or no.
Yes.
All right. This is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right. I'm going to sentence you to 2 years deferred adjudication. I'm going to want felony drug court referral. They should be able to do it because it's 2 years. And I'm going to want a MIC evaluation. Those are to take place while in custody. And then I'm going to want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm going to want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm going to want field visits 1 time per month until further notice. Probation will do proof of employment within 30 days of release, or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm going to want the UA hotline with testing at least once a week. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's anything else your client needs?
I'm not pregnant any further. The air is sucked out of the room with that chillingly vague statement. After all the effort the court made to protect the unborn child, this is the update. The judge, clearly taken aback, asks for clarification, but the defendant offers none. The primary reason for the court's intensive intervention, the baby is gone. We don't know the circumstances, and the judge respectfully doesn't push for the traumatic details, but the impact is immediate. The entire foundation of the previous sentence has crumbled. Probation now has to reevaluate everything, noting they don't have enough to go off of to make a recommendation. The defendant's situation has gone from complicated and hopeful to tragic and desperate.
There's nothing else she needs, Judge. We asked the evaluations be done when she's out in custody.
All right, that will be denied. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, yes,
All right,
sir.
because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Right, yes, Your Honor.
All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge. Since she's been in custody this time,
Mhm.
we've conferred with the DA, and this is the attempt. She's got quite a bit of time. So this is our agreement that we reached.
All right.
She was approved. I know that she's being evaluated for mental at the MIC caseload,
Mhm.
being that it's a misdemeanor, but mental health court, I don't think that was the approach because there wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court? And see if they'll accept her?
Here it is, the final ultimatum. The judge, recognizing the gravity of the situation, lays out two starkly different futures for Miss Lockhart. Path one is to accept the probation officer's recommendation, continue on probation with moral recognition therapy, job skills training, and re-entry services. It's another chance at building a stable life from the ground up. Path two is to give up entirely. The judge offers to revoke her probation and sentence her to the maximum time allowed by law, 365 days in jail. She makes it clear that if Miss Lockhart chooses jail, she has done nothing to earn any leniency, and the time will be served straight. One path leads to help and structure. The other leads to a locked cell. The choice is now solely in the defendant's hands.
Understanding mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial or withdraw her plea, then the court will consider that.
Absolutely. That's what I was thinking ahead, Judge. That's why my brain was going like, I don't know if it looked like I was rolling my eyes. But I was like, does that mean that she wants? Yes. Okay.
All
I'll
right.
explain that.
So,
Thank
LaShawn,
you.
if you can, you're welcome. LaShawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they're willing to accept her, defense is going to file a motion for new trial and the court will grant it. All right, thank you. You're welcome. Have a great day.
Thank you.
And I'll explain in a second what she's doing and it's really helping you out. But,
All right, and they'll put you back in the box so probation can speak with you, okay?
Yes, ma'am.
All right.
Thank you.
Mario, you're welcome. Mario Miranda, Chardonnay Lockhart.
Turn the microphone. I'll keep you that.
It looks like a drinker.
In a heartbreaking and baffling final decision, Chardon Lockhart chooses the jail cell. She tells her attorney and then the judge that she wants the maximum sentence of 365 days. After everything we've witnessed, a judge who fought for her dignity, who exposed poor jail conditions on her behalf, who crafted a bespoke rehabilitation plan, and who offered a path to complete dismissal, Miss Lockhart rejects every lifeline. She actively chooses punishment over help, a year behind bars over a chance at stability. It is a tragic end to a case that began with so much judicial compassion. We see a system that tried its best to help, only to be thwarted by an individual's own devastating choice. What do you think of this outcome? Could the court have done more? Let us know your thoughts in the comments, and be sure to subscribe for more courtroom breakdowns.
Just give me one moment. All right. Are y'all ready to proceed?
Defense is ready, Your Honor.
Yes, ma'am.
All right, court is calling 2022 CR 3597. I'm sorry, y'all need to be silent in the box. We're on the record. Ms. Kramer? That's okay. You can ask them to move your client down to the other end. Court is calling 2022 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state?
Daniel S. Clark, the state of Texas.
Defense?
Mark Darling for the defendant.
And are you Ms. Lockhart?
Yes, ma'am.
Going to show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Chardonnay Leanne Lockhart who was placed on deferred adjudication in 2022 CR 3597 for the offense of attempted arson, reckless causing damage on May 15, 2023 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violate condition number 4 in Bear County, Texas. The defendant, Chardonnay Leanne Lockhart, then and there failed to report to the supervision officer as directed for the months of August and September 2023 in violation of condition number 4.
How do you plead to that? True or not true?
Your Honor, the state waives all the violations.
Any objection?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine? Did you understand that?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is for 272 days in the Bear County Jail and for this to satisfy the judgment, since it's a Class A misdemeanor.
All right, has she done anything on probation?
No, Your Honor.
All right, then why would, well, all right, so you've done nothing on probation. Probation, what are you requesting?
Your Honor, after she was here last in court, she just did not show up anymore. So we understand that there may have been or may be some issues as far as maybe possibly homelessness and so forth. And we were going to ask just to amend for a moral recognition therapy, job skills training, and possibly the reentry center for services.
All right, and will this be set up while she's in custody if I follow this?
We can't set up those things in custody, Judge.
All right. All right,
At the time, Judge, just to also, I know you have your docket sheet. She was evaluated for DDRF. However, we could not do DDRF because at the time she was pregnant. Don't know what the status is of that is at this particular moment, but we just don't have enough to go off of to give any other recommendation, Judge.
all right, Miss Lockhart, can you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Chardonnay Lockhart.
All right,
Chardonnay Leanne Lockhart.
all right. Miss Lockhart, what's the status of the pregnancy?
I'm not pregnant any further.
Okay,
Judge, she,
I mean, how do you mean?
okay. All right, so here's my issue. I don't know if anybody wants to ask any more questions, but I'm not going to give her 272 days in the Bear County Jail. If she wants to be revoked, she can be revoked. I'll give her 365 days at the Bear County Jail, or she can, or I will follow the probation's recommendation.
you understand? Do you agree? Judge, it's Ms. Lockhart's wish that you do send her to 365 days in the Bear County Jail after revocation versus, the alternative, she doesn't wish to make
Right,
those
it'll be a
efforts.
$4,000 fine.
Well,
Because let me just tell you, Ms. Lockhart, here's what the problem is. The problem is that you're on deferred for an attempted arson. You're homeless. You have no job. You've been staying from hotel to hotel. You're going to end up potentially, if I just send you out in the world, you're going to end up getting another theft case or something else is going to end up going wrong with your life if you don't get stable. The only thing that I can do other than continue on probation is maxing you out. And the reason why I would max you out is because you have done nothing. And the reason why I will not run time and money concurrent is because you have done nothing. So the choice is yours.
I pay them.
Well, then you can choose the maximum sentence of 365. Tell the judge.
It's like you stated the first, so exactly what you chose.
Yeah, I'll tell the judge.
Yes, what would you like to do?
Okay, I would like to do the 365 and pay the $4,000 fine.
All right. Are you waiving your right to appeal?
Yeah,
You want to talk to her about that?
Well, I did, and I filed the trial court certification along with the explanation before she signed it. So as I told you, you're not going to be able to appeal your decision to enter a plea of true. So you effectively waived it by tendering that document.
Well, Ms.
You're not going
Lockhart,
to have right to appeal.
if you want the court to sentence you to the 365 days with a $4,000 fine, time and money not run concurrent, are you waiving your right to appeal?
yes,
I'm sorry?
yes, ma'am.
All right. Court will grant the motion, find you guilty, sentence you to 365 days in the Bexar County Jail, give you credit for any time served. There's a $4,000 fine. Time and money is not to run concurrent. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am, I did understand.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.